Pyre, and we are planning to have a short introduction. I'm then going to introduce the different people who are going to be participating on the panel today. And then I want to briefly mention a new part-time member of the Information Regulator who has been voted on by the National Assembly yesterday. And then we want to find out more about you as an audience. We'll be running a few polls, and if you could be really quick with answering the polls so that we can get a feel for who you are as an audience and what you're interested in, what questions you're seeking answers to, and what solutions you're trying to find. And I think that's the key purpose of today. We came up with the wording of saying, let's call it a joint solution finding session. And so today's not about posing questions to the Information Regulator and grilling them. It's about really the panel collectively and all of us trying to find answers to some questions and trying to find solutions of how we can work together to protect personal data and improve access to information by 1 July 2021. And I think for me, many of the questions that people are asking us are really tricky questions, and often there aren't answers, or the answers are complex and there is a lot to them. And so collectively, I think we'll be able to find the answers to the questions. And I really welcome questions. So I know many of you have sent questions before today's session, which I've collated, and we can tackle as many of those as possible. And please also ask other questions, either in the Q&A box or in the chat box. Either of them would be a good place to have those questions. All right, so my name's Giles. I'm the managing attorney at Michalsons, and we're very pleased to have various people from the Information Regulator with us today. Firstly, I'd like to introduce you to Advocate Colin Wiepond. And if I share my screen quickly, I'll come back to Colin, but there's information about Colin that you can find on the website. He's one of the full-time members of the Information Regulator, and it's very nice to have Advocate Wiepond with us today. So welcome. We then have two other executives from the Information Regulator with us today. First is Mrs. Varsha Sulal, and Varsha is the executive responsible for legal policy, research, and information technology analysis. And it's really great to have you. So thank you very much for joining us, and welcome. And then we've got Mr. Nemasisi, who is the executive for Promotion of Access to Information Act. And so looking at the access to information component of the regulator's work. Welcome, and it's very nice to have you with us. And then we've got, from Michalsons, we've got two people. We've got Mark Hank, and I'll quickly show you Mark's overview over here. Mark needs very little introduction. Mark is a experienced attorney who's been working on IT and data protection law for many, many years. He was part of the team that drafted Pyre, and he is currently helping lots of organizations to comply with Pyre. Mark, welcome.
Thank you, John, and welcome to everybody else.
And then last but not least, we've got Nathan Ross Adams. He's one of the attorneys at Michalsons. And Nathan is a talented individual who's a creative thinker with commercial experience in software and advertising industries. He's also very passionate about AI and robot law. And he's going to be playing a coordinator role today, trying to collate the questions that you're asking through the chat box and posing those questions to us as the panel. So welcome, Nathan.
Good morning. Thanks very much, John. And I'm looking forward to engaging with everyone today.
Great. All right, then I thought that I would mention that I think it was yesterday, actually, that the National Assembly voted almost unanimously for Alison Tilley to fill the vacant role of a part-time member at the regulator. And it's very exciting news, and we're very pleased that she has. I'll just share my screen here, and this is Alison's LinkedIn profile. She is really quite an exceptional person. She's an attorney. She then has worked in various organizations like the Open Democracy Advice Center, and also in the organization called Judges Matter, and really has been an activist and very involved in many legislative processes, and in Parliament she's made a huge contribution. She's also done a lot of work in the context of access to information, and we're very pleased that she's going to be part of the Information Regulator. Mark, do you want to add anything about Alison? Sorry, Mark, I think you're on mute.
Sorry about that. I've worked with Alison for many years. She was part of the South African Law Reform Commission that researched privacy law in South Africa and drafted the first drafts of PUPI. We spent a lot of time in Parliament together, and she's an exceptional lawyer, and she's also just an exceptional person with a very good grasp of the rights of people wherever they might be. So I'm very thrilled that Alison has been appointed, and congratulations to Alison. I think that comes from everybody at the Information Regulator as well. Thanks, John.
Thanks, Mark. Great. So the next thought I had is to do a few polls quickly. So this is the elections. This is the fun part, the interactive part. So please be really quick with your fingers and choose the answers to the questions. I'm hoping to keep this short because there are quite a few questions. It'll be really interesting to see the answers. So the first question is, what's your role in your organization? And if you wouldn't mind ticking the one that's most appropriate to you. And wow, I see we're almost at the 500 attendee mark, which is fantastic. Thanks. So you're doing very well in terms of answering fast. We're at 60%, going up fast, so that's great. So I think I'll leave it there and quickly share the results with you. And so we've got quite a spread. It's interesting, quite a few information officers, which is fantastic. People from compliance and other as well. So a real spread in terms of the role that people play. Then I quickly wanted to ask what the sizes of your organization. It's really interesting to get an idea here. And this is based on the number of employees. The reason we went with that is because some organizations, and at the moment it's if you're less than 50 employees, you're exempt from having a Pyre manual. And then in Europe, if you've got less than 250 employees, you're exempt from creating a record of your processing activities. And so there's a possibility, I think, for some exemptions, and it would be an interesting thing to talk about in the context today. And it's just interesting to see what the audience is made up of. So we really, most people have voted, so I'll end it there and share the results. So we're almost an even spread, but mostly large, but we've got small and medium as well, which is interesting. Great, and then on to the next one. So this is a really quick and easy one. It's, what are you more interested in POPIA or Pyre? So promotion of access, protection of personal information, or promotion of access to information? Wow, that's fast. Imagine if we could get election results this fast in elections, it would be fantastic. All right, I'll end that poll there and share the results. So by far the majority are interested in POPIA, which is really interesting. The next question that I wanted to ask you is really, what is the main thing that you need now to help you to get ready for the deadline? So you can choose many here, but please don't choose all of them because that won't really help us. Try and pick what are the main things that you need right now. And you know, the deadline is fast approaching. Before we know it, we're going to be into December, and then we'll have the December break. We'll be back in January, and then it really will be 6 months. So there's very little time. And so the question is, you know, what do you need? What do you need from the regulator? What do you need from others in order to make progress and get ready for that deadline? thanks very much. That's I'll give you a little bit longer because there's still many people voting. All right, I'll share the results there. So it's know-how and guidance. That's really interesting. And I think that's part of what today's session is about the Information Regulator and Michalsons giving you some guidance and trying to answer as many of your questions as we can. Then it's interesting that many of you are looking for tools like software platforms or templates. And I'm interested, not many people are saying more money, which I'm surprised about. You know, definitely a theme that I'm seeing is that obviously with the Minister of Finance's budget speech this week, or was it last week? Yeah, last week, really saying that we as a country need to tighten our belts, we need to spend less, and there are going to be cuts in various places, which I think is not good news for the Information Regulator and trying to get a budget. But at the same time, many organizations obviously struggling because of the economic downturn due to COVID. And so I think everyone's under pressure from a money perspective, but I'm really interested that only 7% of you said that that was the main thing you need right now. So that's a really interesting result. Thanks very much. And it's interesting to see that. So we're almost there, a couple more. So now let's move on to the questions. So what I'm interested here is, what topics are you most interested in and would you like us to focus on over the next little while? Now again, maybe don't tick all of them, maybe try and pick the ones that are most relevant to you. We're almost there. So at the moment, spoiler alert, we're really getting a spread across the whole lot. So it looks like you're interested in everything, which I suppose isn't surprising. They are all important issues. But maybe the information officer is got a slight lead, and also access to information and cross-border transfer. So it's a spread across everything. I'll quickly share those results. So as you can see, it's pretty much a spread across everything. And then the last one, and then we'll get cracking with the questions. So I wanted to ask here, which questions are you most interested in? Again, maybe just tick the ones that are most relevant to you. So we're almost there. All right, I'm going to end the poll there and just share the results. So really, it's a match. People are interested in all of those questions. So we'll tackle all of those questions and then also focus on those topics that you mentioned. So let me jump into the first questions, unless there's anything that any of the panelists would like to add at this stage. No? Okay, great. So the first question is, who needs to get prior authorization from the Information Regulator? And maybe, Varsha, if I can hand this one over to you.
Absolutely. Thank you. I think you're going to have to look at section 57.1, and let me just have a brief squiz at my act. If a responsible party intends to process any unique identifiers of data subjects, then they are going to have to seek prior authorization from the regulator. And 57.1 drills down and states that if you're going to utilize information for a purpose other than which you had initially collected it for, with the intention of linking that information with information processed by other responsible parties, then you are going to have to look at getting prior authorization. And also processing information on criminal conduct or unlawful or objectionable conduct on behalf of third parties. And when you're processing information for the purposes of credit reporting, and also in terms of transferring special personal information in terms of section 26, or the personal information of children in terms of Section 34 to a third party in a foreign country that does not provide an adequate level of protection in terms of processing in accordance with Section 72. And I think there will probably be questions on transporter information flows and adequacy and how that will be dealt with. But that aside, I think the regulator also has a discretionary power in terms of Section 57.2 to expand the requirements of prior authorization to include additional types of information processing by law or regulation if the processing conveys a particular risk for the legitimate interests of the data subject. So that discretionary power is there to extend application for prior authorization in terms of my interpretation. Thank you. Thanks, John.
Thanks, Varsha. Yes, and I've just put up the screenshot here of Section 57. And maybe just to dig a bit deeper, a lot of people have asked us questions around some of the details here. So for example, they've asked us, what does credit reporting mean? Because the term's not defined in the Act. Is the regulator planning to give more guidance or clarity on when you do and don't need prior authorization?
The regulator is intending to do so. We will be providing a guideline before the 30th of June next year. So we can look out for that. And I think at this stage, we haven't explored defining credit reporting, and we will be, in the guideline, I'm sure we will explore all the pertinent concepts that would need to be addressed to ensure that there's a comprehensive understanding of how prior authorization will be implemented. Thanks, John.
Okay, great. So I think the other tricky question here is around, and you correctly mentioned it, is that if there's a transfer to a foreign country that does not provide an adequate level of protection for the processing of personal information. And I think this is a particularly tricky one, given the Schrems II judgment and trying to work out which countries South Africa would regard as having an adequate level of protection. Is the regulator planning to have a list of almost an adequacy finding of the countries that you consider to be adequate?
I'll take that as well, if it's okay, and my colleagues can jump in. We are going to also compile a guidance note on transport information flows, and it would have to be that the regulator addresses a list of countries where we find the data protection framework adequate. I think that would make it much easier for implementation of the Act. Yes. And it's due to come in time. Thanks.
Fantastic. That's good to hear, and I agree. And it's, I mentioned at the beginning that some of these questions are really tricky, and it is very hard because the whole world's grappling with this issue. The EU is trying to decide whether the United Kingdom have adequate levels of protection, and and the Schrems II judgment really had a big impact as well. So it's a tricky one, and it'll be fantastic if the Information Regulator can give us some guidance. I think it'll help a lot in the context of cross-border transfers, and also then in the context of prior authorization. So,
John, if I may just ask a question of Varsha and the other panelists from the Information Regulator. Varsha mentioned that the guidance note on prior authorization would be out before the 30th of June next year. The difficulty that some of the clients, or many of the clients that I'm consulting with, is that they definitely fall within the Section 57 categories. And Section 58 specifically requires that they do not process information without prior authorization. But of course, and I think that we can foresee that there are going to be a lot of applications for prior authorization. And there's a period allowed of 13 weeks for decisions to be made. So is it, and again, I'm not trying to put anybody on the spot, but it seems to me that it's necessary that the guidance around prior authorization is really accelerated to allow applications to be made. Otherwise, we could have people processing that information from the 1st of July, but they haven't had the background to be able to make their applications properly. I don't know.
Thanks, Mark. Yeah, no, thanks, Mark. You know, I gave you a very broad deadline, but I think internally we're looking at the 31st of March, more so. And obviously, if it's done much sooner, it will be released. We're very mindful of the timeframes, and the Information Regulator is committed to making sure that we can enable compliance with the Act. Thanks. Thank you, Mark.
Thank you. Thanks, Varsha.
Great, and I think that's fantastic, because I have a lot of people have raised that they're very anxious about this issue, because if they have to get prior authorization and they don't, it's a criminal offense with 1 year in jail or about R1 million as a fine. So I think people are really worried about it, and they're wanting to have as much guidance as possible. And so some of the thoughts that we had, which I'd be interested in the Information Regulator's thoughts, is that possibly there would be the possibility of authorizing a class of responsible parties. So for example, if you have employers who do criminal checks on certain employees, you'd be able to give almost a blanket authorization to a class of people. And that might be one way to reduce the workload on the Information Regulator and enable more people to get prior authorization quicker. So I guess it's more a comment than a question.
Maybe I can add to that. I think the stance that the regulator is going to adopt, and it's a preliminary view, is that, you know, I think every application is going to be considered on its own merits. I don't see at this point any blanket authorizations being sanctioned. But I mean, it's, as I said, it's a preliminary view. Thanks.
Okay, perfect.
And maybe if I can add, if you look at section 57, it says a responsible party. So it's very clear that it will be an individual application for a responsible party to apply for prior authorization. But I think also maybe one should mention that if there's a code of conduct issued by the regulator and that code of conduct is in operation, therefore section 58, it's excluded. You don't need to have to apply for the prior authorization. So if with regard to the issue that you raised about the class of person, so the class might only be applicable if that class of person or in the specific industry, they have got the code of conduct issued by the regulator, which automatically kicks out the requirement of prior authorization. I hope that clarifies.
Yes, I think that's a great point, and thank you for raising that, because I think that will take a lot of pressure off the regulator and also off a lot of responsible parties. And I agree with you, associations and industries need to be creating codes of conduct that would then be issued by the regulator, and it would mean that they don't need to get authorization directly from the regulator. So I agree, I think that's definitely one solution to the problem of enabling everyone to get prior authorization before the deadline. I think the other issue that people have raised is that they're worried that there will be the deadline, and they will, and many are going to leave it to the last minute. I think that's just human nature, but they're worried that there'll be a mad rush into 1 July. And so any way in which we can alleviate that, I think, is important, and I think codes of conduct play an important role there.
I think you're right in terms of the issue on codes, and we're really hoping that before the end of this year we can publish the guidelines. We received a massive comments, and we're close to the end in terms of finalizing the comments and considering each and every one of them. So I think once the codes are in place, and once people start have their approved codes, it would certainly deal with the issue of prior authorization to a great extent. Thank you.
Okay, perfect. And I also, the other question people ask is, well, how will I actually get this prior authorization? So practically, will I fill in a form on the Information Regulator website, or will it be a manual process? And I think I read in the Information Regulator Readiness Plan that the idea was to investigate using software or technology, and I think I remember a date of 31 March of aiming to have something in place. But any guidance?
Yeah, you're right. You're absolutely right. We're going to develop a pro forma. It'll make it easier for us. We want consistency, and you're right about the date of 31st March. That's what we're looking at. Thanks.
Okay, great. All right, let's move then on to the next question, which is, when is it contemplated that the Information Regulator will take over the regulation of Pyre from the South African Human Rights Commission? I'm not sure who would like to take that one.
I can take that.
Sorry, Michael. Mr. Nemasisi will take it. Thank you.
Thank you, Member Wiepond. If you remember, Section 110 and 114.4 are only coming into operation on the 30th of June 2021, and that effectively means that in the meantime, the South African Human Rights Commission will continue with its function for under Pyre. Then they will transfer those functions to the regulator on the 30th of June. But what will happen is that with regard to the Section 32 report, you remember for public bodies, all public bodies need to submit their Section 32 report to the Human Rights Commission. That will continue until next year, September. So we'll only require parties to submit their Section 32 reports in 2022. So in terms of the arrangement that we have the Human Rights Commission, because we're assuming this responsibility in the middle of the year, they will continue with their function, their function specifically with regard to the Section 32 report. However, the rest of the functions will be transferred to the regulator on the 30th of June 2021, except for the Section 32 report, which they'll continue until they submit their report in September 2021, and then from the following year, then we take over that function. Thank you.
Fantastic. Thank you very much. That's very useful. I think a related question is something that's also causing quite a lot of anxiety with people, is that for the requirement to have a Pyre manual, the certain people are exempt every 5 years. And that's where I was mentioning organizations who have less than 50 employees or turnover of less than a certain amount are exempt from having a Pyre manual. And a few people who are currently exempt or are close to being exempt are asking us, is that exemption going to be extended for another 5 years? And will the thresholds be increased? So in other words, could we go from 50 to 100 employees? And could we go from 15 million turnover to 25 million Rand turnover? Is there any guidance you can give us on whether that exemption will be extended and whether the thresholds will be increased?
With regard to the threshold, we are not sure, but we are sure that the exemption will be extended. The South African Human Rights Commission has, I'm sure they've already done so, because in the last meeting that we had with them in July, we discussed this issue of extending because we knew about the deadline, and they undertook to prepare the necessary documents for the minister to sign. So we hopefully that before this current exemption expire, that will definitely be extended by another 5 years. With regard to the threshold, we are not sure yet as to whether that threshold will be changed or it will be remain as it is. But it will definitely be extended. The exemption will definitely be extended because it's not practically possible to have Pyre manual for the small company that employs 2 people or 3 people. So the exemption will definitely be extended. Thank you.
Okay. Fantastic, thanks. That's really good news. And I think it's really important that the exemption's extended before the end of the year, because the 5 years ago when it happened, it was a little bit late. And what happened is that various opportunists then started shouting from the rooftops that everyone had to have this manual because now nobody was exempt anymore. And a lot of small businesses who were and should have been exempt ended up paying for a Pyre manual that they really didn't need or have to produce. So I think it would be fantastic if that could be before the end of the year.
John, if I may just raise a point with Nemasisi relating to the question of notification in terms of Section 18 of the Pyre. Obviously, there's an obligation to keep documentation relating to the processing activities, etc. Is it contemplated by the regulator at this stage that where parties have manuals, that will, and as long as they abide by all of the requirements of Section 18, that will be sufficient notification for the historical data, because we are in a situation in South Africa where there is this delay essentially with data protection legislation. And we've had a long period of companies and organizations gathering a lot of personal information. And there is the exemption, or not the exemption, but the proviso relating to notification of where it's not practically possible. And I'm just wondering whether the regulator has considered the issue of notification and whether Pyre manuals will constitute sufficient notification as well. I don't know.
Look, now, I can take that. If you look at the amendments brought by Popia, you will see some of the requirements. You need to specify in your manual what personal information you'll be processing. And that manual has to be updated annually. Is it annual or biannually? I forgot. But that information that you contain in the manual, it normally be available in your website. And the people who want to know what kind of information you process, they will be able to see in that manual as to what is it that you are processing. But obviously, with the challenge is that with regard to the entity that are exempted, so anyone who are using the service of that particular entity which is exempted, they may not be able to know what kind of personal information the entity is processing, which therefore there must be any other form of notification. We have not determined what kind of notification you can have. I guess just thinking out of my head, some of the process might be if website, you put that information on website as well, if you're exempted. But the Pyre manual definitely will actually specify if your manual is properly drafted in line with the requirement. You will be able to specify what kind of personal information you process, and that will actually help anyone who would like to know whether their information are being processed or not. But that it depends on how your Pyre manual is drafted. So if it's so specific, that it means it provide clarity. But if it's not specific, it means a data subject might actually still request you in terms of section 23 to check whether their information is being processed or not. But the Pyre manual will definitely share some light on that aspect.
So it may well be, and I'm really not, again, stipulating, I'm just suggesting that it may well be that where companies that, for instance, process big volumes of information, and typically they will be larger companies and will have Pyre manuals, that as long as they meet the requirements of Section 18, that's fine. And obviously, in terms of Section 18 and the amendments to Pyre, it is necessary to also notify the data subject of their rights of participation and to be able to check their information. So what I'm gathering is that that might be a mechanism that would be considered by the regulator as being sufficient.
No, definitely. If you look at the requirement of Section 18 of Popia and you look at the requirement of Section 14, the one that deals with manual, you will see that they're actually similar. It talks about the nature of the information that you are actually processing, the purpose of processing that personal information. It also deals with your addresses. And those are the things that you normally contain in the Pyre manual. So it definitely, the Pyre manual will share some light. But obviously, the regulator will give certain directives with regard to how certain things should be done. But I think Pyre will be the first step towards complying with Section 18. But the regulator will provide a clear guidance as to, is there any other aspect that need to be attended by the responsible party over and above the Pyre manual that would have contained the information that's required in terms of Section 18.
Thank you, Nemasisi. That's very helpful. Thank you.
Yes, thanks. And while we're on that topic and talking about exemptions, what many people ask us is, will certain people be exempt from certain things under Popia? And one of the things that came to mind was the obligations and the responsibilities of an information officer. If you look at the GDPR, for example, only some organizations need to have a data protection officer, not everyone. And we always say to people that no, nobody will be exempt from having an information officer. But I'd be really interested if anyone in the panel had any views on whether possibly there could be a link between Pyre manuals and information officers and the exemptions.
Maybe I can take.
Okay.
Mr. Nemasisi will take it. Thank you.
Okay.
Thank you, Member Wiepond. If you look at section 14, subsection 5 of Pyre and section 51.4 of Pyre as well, they provide for an exemption of, for example, of your private bodies from compiling manual. But if you look at section 55 of POPIA, it does not contain any provision of an exemption. It says a responsible party must obviously be registered, the information officer must be registered with the regulator, and it does not specify if there'll be any exemption. And automatically, by mere interpretation of that section, it means there would be no exemption with regard to the information officers. So each and every responsible party that is processing personal information must register with the information regulator because the POPIA does not provide for any exemption. Thank you.
Thanks very much. And I agree with you. I think that is correct. And that's what we've been saying to people. I'm not sure, Varsha, did you want to add something as well?
No, I'm actually good. I think Mr. Nemasisi covered it more than adequately. Thank you very much.
Okay, fantastic. And then a related question to that people ask is, how are they actually going to register their information officer with the information regulator? And we normally say to people that the information regulator readiness plan has pointed out that you're investigating a system where people will be able to go onto a portal on the information regulator's website and register that person online. Is that correct? And anything else you can share with us there?
Thank you so much. Yes, I think it's very important to note that the regulator is still in the process of setting up its systems and its processes, but simultaneously we're looking at the guidance or the guidelines on the registration of information officers, because we also received some submissions which we need to consider. But after that, the systematic issues or the systems that we need to consider will also then be mostly a push towards the electronic or online, so that we just lessen the volume of physical documents, which could also be some extent risky. But what is very important for us to appreciate is that we also need to take a note of the fact that not all the companies, all the responsible parties across South Africa will have the necessary systems in place to actually then also do the online registration. But what we would want to do is to just look at this aspect more carefully and then also then provide the guidance necessary in due course. Thank you.
Fantastic, thanks very much. A related question to that as well, actually, is that, and I'll just read the question here. So Dr. Johan Kutsia asks, can the default information officer delegate the responsibility to a person who is not employed by the organization? So in other words, outsource it to another organization.
Thank you so much. I think what is very important to understand is that the information officer can delegate his or her power to the and responsibilities to the deputy information officer. But what is very important to note is that there's no provision that allows for delegations outside that specific responsible party. And I'd also like Mr. Nemasisi to make a comment on this position that I've just explained some in more detail. Thank you. Over to you, Mr. Nemasisi.
Thank you, Member Wiepond. You're correct. The information officers they take full accountability for their responsibility in terms of the Act and regulations, and they can designate a deputy information officers They can have, if the big companies can have 1 or 2 or even 10 deputy information officer, depending on the nature of the company. If the company is big enough and it received a lot of requests for access, so they can appoint more than 1 deputy information officers. Because, and the reason why the Act, I think, prescribed that 1 or more is because those people are actually not employed as information officers only, they've got other duties. They just designated. So what will happen is that you can only designate a deputy information officers. I think what we need to differentiate is between a designation in terms of legislation or getting an advice as an information officer or as an entity. So with regard to the delegation or designation, that can only be done to the deputy information officers. But that does not prevent anyone from getting an advice from whoever they would like to get an advice from, but that person will not be recognized as a designated in terms of the Act. So the Act recognizes the information officer and the deputy information officer. Thank you.
Okay, fantastic. And I guess that the guidelines that you'll be publishing on the information officer, based on the comments that you've received, will give more clarity to these issues, and we'll wait for that. I thought let's quickly go to Nathan Ross. And Nathan, have there been any questions related to what we've been discussing right now from the attendees?
Hi, John. Yes, there have been quite a few questions, and there have been quite a few, sorry about that, and quite a few consistent themes as well that have been coming through. The first theme relates to the Act itself and how it's currently structured. Basically, the question is whether the Information Regulator will release any plain language guides of the Act, as well as guidance notes, because some of the people on the webinar have been relying on the UK ICO notes, and they just want to know if there's anything similar that will be set up by the Information Regulator.
Thanks. And if I can add to that, we've also been asked by people whether the regulator is planning a general public awareness program to raise the awareness of the public. And I think it was interesting in the poll at the beginning of today's session that many people said that they wanted know-how or guidance. So I think that is a great question. Would anyone from the panel like to take it?
I'll take it, John. I think that I don't know about whether we're planning on releasing a plain language guide to the Act as yet, but I do know, and in terms of our readiness plan, we have identified several issues that we would like to augment and provide guidance on. For instance, and we've mentioned the issue of prior authorization, exemptions, trans-border information flows. And I think it's also going to be necessary that we look at concepts like legitimate interest and public interest, because those will help in implementation of the Act. And in terms of public awareness programs, the Information Regulator is already has already embarked on numerous campaigns. A lot of them are virtual, obviously, in this time. And raising awareness and understanding on the Act is a key undertaking that the regulator has made and has even committed to Parliament in that regard. So it's definitely high up on our list of priorities, and it's something that we are not going to we are going to continue doing. Thanks. Sorry, it seemed like I had a call coming in.
Yes,
thank you.
And
sorry about that.
And exactly, and I think what demonstrating what you've just mentioned, that's what today's session's about, and it's we really appreciate you making yourselves available to participate in a session like today. I think, Nathan, before we go back to you, another related question that people have asked us is, they've asked, will the regulator publish my breach notifications? And I think it's a connected issue in that people, I think, are worried that they have to notify the regulator of a breach, and that the regulator might then have a section on their website which is almost a register of breaches. Is there any plan to do that or not?
I will answer that question to some extent, and my colleagues will also come in. I think that the regulator is committed to working with responsible parties, and there's no way that we've articulated a different position. But there's a very fine line between that and ensuring that public and I think the Information Regulator is going to publish information that will be in the public interest. And if we look at section 41A 3, the regulator has to make public statements in relation to any matter that it deems necessary for the public to be aware of in terms of the protection of personal information. And also, if you make reference to section 42, the regulator has a discretion to publish reports from time to time in the public interest or in the legitimate interest of any person or body of persons. And generally publish reports relating to the exercise of the regulator's functions. And I think if you look at section 22, section 22.6, the regulator also has a discretion to direct a responsible party to publicize in any manner specified a compromise. So I think that it's going to have to be on a case-to-case basis, and I don't think the regulator is going to issue a blanket position in that regard. I believe that public interest will be foremost in determining that. Thank you.
Great, Jan, I agree. The other point with the breach is obviously the responsible party needs to notify the data subjects who are affected. So I think the point being is that the regulator is not going to name and shame people, but where it's in the public interest that it gets made known, it will. And the key point for responsible parties to remember is that you're not going to be able to hide from the fact that there was a breach. It will be public knowledge.
Thank you, sir. If I may add,
yes.
What is very important to appreciate about data breaches as well is the fact that it doesn't matter how small the data breach is, it needs to be reported. And also the fact that we don't have a materiality threshold in place currently. And what is also very important to note with regards to data breaches is that it might or could be difficult for the information regulator to find a good basis to say on what basis would we want not to make public the responsible parties that have reported data breaches. So even though it will be on a case-by-case basis, but there must be careful consideration, also taking into account that we are responsible for the promotion of access to information. So it is a balancing act, but it's also one that needs to provide in the public interest, the public of South Africa with information that would allow them to make informed decisions, because most of us would maybe also have an interest in the type of data breaches and the type of and the number of responsible parties that will breach, so that we can take precautionary measures. So from that angle, it becomes very important to appreciate how the regulator will go about in publishing the names of responsible parties that have had a data breach. Thank you.
Thanks very much. Anyone else from the panel want to add on that issue?
I think that just, John, it is an important issue. And one of the things that is important that we're seeing in other jurisdictions is the emphasis on resilience in information security. So one of the issues is, it is quite possible that you do everything you think reasonably necessary and you're diligent about information security, you might still have a breach. And the point is that very often it is the data subjects who are in the best position to protect themselves where there is a breach. And in those circumstances, obviously the need for notification is important. But equally, I think that one of the things that we need to look at is, it's all very well, like a whole lot of other things in life, it can happen. We could have a problem somewhere along the line, and how quickly we recover has become a very important aspect. And I'm certain that in dealing with data breaches, well, when I say I'm certain, I strongly believe that what would happen with data breaches and the regulator is that where there's a data breach and the parties have acted diligently, it's not to say that the regulator will not act, but they're going to look more kindly on those people that have actually looked to protect the personal information of data subjects beyond a breach. And therefore, resilience becomes very important in considering how you deal with data breaches, and hence it's been included in legislation that was written after the Pyre. We see that increasingly. Thanks.
Great, thanks, Mark. And before we go back to you, Nathan Ross, I wanted to ask another question, which is a bit of a cheeky one. And I know the answer, I think, but I thought I'd ask it anyway. Lots of people ask us, is the deadline going to be extended past 1 July 2021? And we've consistently said no. The regulator said no. And I thought I'd just ask it again.
Thank you so much.
Okay,
yes.
Sorry.
Oh, okay. You can go, Ms. Sula. You can answer. Thank you.
Thanks. I think it's going to be an emphatic no. Sorry.
Yeah, no, you have been consistent in saying that. Yeah. All right, Nathan Ross, should we go back to you? Are there any other themes in terms of questions that have been coming through?
Yes, so I'm actually just going to follow up with the theme of data breaches. So there was one question that related to, will there be a guidance note on what actually constitutes a data breach and what isn't a data breach? And then linked to that question was about where a company or organization rather doesn't report a data breach and there's a whistleblower that reports it on its behalf, or not on its behalf, but rather reports it, will there be any protection for such whistleblowers?
Thank you so much. It's a very good question indeed. Remember, our law should not be appreciated differently from the Protected Disclosure Act, because we need to appreciate what the Protected Disclosure Act is saying, even with regards to the rights of employees, and that becomes very important for us in the workplace as well. So there will be some type of, in looking at the guidance note that you're referring to, it might be opportune for the regulator to consider a possible guidance note, and I'll also then raise that specific question in our meeting, so that we can also then add it to the list of guidance notes that we should be working on. But what is also very important to appreciate is that employees that are actually reporting a data breach without the consent or the permission of the employer. Obviously, I'm not 100% sure, but I think there might be an aspect of a protected disclosure that might be useful for them at that side. But from the information regulator side, it's also very important to appreciate that whatever and this was highlighted by Mr. Marking, that if they don't report a data breach, a responsible party fails to report a data breach, and we get a whistleblower who have taken the necessary step to report it, then that factor will also be taken into account when the regulator considers the issuing of a penalty. So all these factors will then come into play. Thank you so much.
Yes, for me, some takeaways there are, don't try and hide it. If you have a breach, then notify it. But I think also, Nathan Ross, the words for me that I often get asked about are these words that I've just highlighted on the screen there, which say that where there are reasonable grounds to believe that the personal information of a data subject has been accessed or acquired by an unauthorized person. And I think that's where people get stuck, because something happens and then they try and test it against that condition, and they get unstuck because reasonable grounds is very vague, and whether it's been accessed or acquired. And so I think it's a good question, and I think any guidance that the information regulator could give around that would be very useful. And I think in the interim, responsible parties should err on the side of caution and notify if they're not sure. If they're uncertain, better to notify than not to notify. Back to you, Nathan Ross.
Perfect, thanks very much. And then when it comes to data breaches and government departments, there was a question about whether Pyre applies to government departments and whether they also have a duty to report breaches to the information regulator.
Thank you so much. The issue of government departments that are supposed to report or not report data breaches, the Act is quite, if you look at Section 19, it does not draw a distinction between government departments or government entities or state-owned entities and the private sector. Everybody needs to report data breaches as long as you are a responsible party processing personal information of data subjects. You are required to report a data breach to the Information Regulator. And very important to note, it does not matter how small or how big the data breach is, but it is a requirement that all data breaches need to be reported. The issue that that was raised in one of our webinars was that if we continuously have a very low threshold data breaches that we experience and the volume thereof, is it still necessary to report it on a case-by-case basis, or do we have to maybe look at reporting on a monthly basis and then gathering all of these small data breaches? I think that's one of the issues that a regulator should need to consider in a guidance note, and that should also then help with regards to the guidance that we need to provide to industry. But there's no distinction between the reporting of data breaches that were experienced by government department vis-a-vis the private sector. All data breaches that are experienced by responsible parties must be reported to the Information Regulator. Thank you.
And I think, yes, Mr.
So I wanted to add something with regard to the notification. If you look at Section 22.3, it talks about the responsible party may only delay notification of data subject if a public body responsible for prevention, detection, or investigation of offenses. So that will normally be your SAPS, or the regulator determines that notification will impede the criminal investigation of the public body concerned. So there's the issue that I want to highlight is the determination by the SAPS or the regulator. So unless you receive this determination, you therefore have to report that data breach as soon as reasonably possible, as required by the Act. So what is the most important thing that I wanted to highlight is that if the matter is reported to the SAPS and you have not received any determination from the SAPS or the regulator, then you cannot therefore delay on your own. You need to get that determination from the regulator or the SAPS that the public the data subject should not be notified of that particular breach. And that's the point that I thought you should highlight as well. Thank you.
Great, thanks very much. Another question we've been asked, Charles asked is, he asked, can the Information Regulator answer questions and how would they go about doing it? So I think in addition to releasing guidance notes, if somebody has a specific question on an issue, are they able to ask the Information Regulator, and how should they do that?
Thank you so much. I think this is a very important question to the functions of the Information Regulator. We need to be very careful about what a regulator can do and what a regulator can't do. So we need to distinguish between guidance that the Information Regulator can provide in general, that is allowed, but the Information Regulator cannot provide legal advice. And most importantly, on the interpretation of the provisions, because of the fact that if something happens which might then serve before the Information Regulator in the form of a breach or whatever kind of situation, we might then be conflicted because of the type of advice that we have provided. So we need to be very careful about what the regulator is supposed to do and can do vis-a-vis the guidance of a general nature, because guidance is not actually specific, conclusive opinions. And what is also very important for the Information Regulator to consider is that advice should be provided by other parties other than the Information Regulator, because of the fact that if matters come to serve before the regulator, then the regulator is in a position to appreciate that specific position, that specific advice or interpretation, and not be part of that interpretation, which might then potentially raise a conflict of interest. Thank you so much.
I think that's a great point. I've given a lot of thought to the distinction between legal guidance and legal advice. And legal guidance is generally a one-to-many type scenario, which is information that's relevant to many people, whereas legal advice is often a one-to-one scenario, and it's information that is specific to one client and their specific issues. And it's really useful, and I think that's a very important point that you raised, that the information regulator can't give legal advice. All right, we've got lots of other questions. I've got a few more here. The next one that I thought we should touch on is, it's quite a technical question. Quibus asks, in the context of section 69, so direct electronic marketing, you're allowed to direct electronic market via, say, email or SMS to customers. And you've got existing customers, and then you'll have future customers. Is it true that that applies both before and after the deadline at 1st of July 2021, that you'll be able to market to customers on an opt-out basis before and after the deadline?
Ms. Fuller, can you take the question, please? Thank you.
Thanks. Do you know, we are going to be preparing a guidance note on electronic marketing where we're going to be dealing with these issues. And I don't think we're going to be giving a blanket position at the moment regarding that issue up until that note is out. Thanks.
Okay. Yeah, well, it's a tricky technical question. I must say my thoughts are that yes, that the law does enable it. But I agree. I think any guidance would be useful.
I think Mr. Lance is correct, but maybe to add is that if let's say, for example, you have got a database of customers that you have been contacting. Remember, when POPIA comes in, it's not retrospective. It obviously applies from the date in which it becomes effective. POPIA came into operation on the 1st of July 2020. I know there's a perception outside there that the grace period suspend the effectiveness of POPIA. It doesn't. It gives you opportunity to put measures in place to be compliant. It does not say, there's no way the way it says by end the grace period you are not, therefore we suspend compliance with POPIA. What does that mean? With regard to the direct marketing, it means if any processing that happens after the effective has to be in compliance. We're not talking about what happened in the past. So if you have got a database, but you have not received consent, therefore, if you are going to process after the effective date, you need to ensure that you are in line with section 69, the requirement of consent, unless there's an exception that's applicable. So whoever's going to process after the effective date of POPIA, which is the 1st of July, need to ensure that whatever they do, it's in line with POPIA. And that's the critical thing. Although the guidance note, I think that Ms. Sula was talking about, will provide a clarity. But I thought that's very critical, that people must understand that the fact that you've got database does not authorize you to continue doing what you've been doing in the past. Because now that the act is in operation, you've got to ensure that whatever that you are processing at the from the effective date has to be in line with POPIA. Thank you.
Great, thank you very much. That's useful information. The next two questions relate to accountability, and again they're reasonably technical, but it would be interesting to get your thoughts on it. The question is, can a holding company in South Africa be fined by the ICO if its subsidiary is in the UK and it contravenes the GDPR? And maybe this is unfair to ask you, maybe we should be asking the ICO. Just occurred to me now, but yeah, and so I think that the answer to that is that I don't think so. I don't think that the ICO will be able to fine the holding company, but it is quite a tough question, I think. And then the related one, which I think is closer to what we're talking about, is that how closely will you be working with authorities in other countries? And I think the concern is that the information regulator might take action against the holding company in South Africa, and then an authority, let's say the ICO, takes action against the subsidiary in the UK and effectively gets fined or gets fined twice for the same contravention. Any thoughts about that?
Yes. What is very important to appreciate about this aspect, we need to refer to the Cambridge Data Analytica data breach. And that provides for us a very good platform about what different jurisdictions have done. If you look at the ICO, they initiated an investigation. If you look at how they have communicated with other authorities, such as the US, etc., that becomes a very it becomes a very solid approach because of the fact that because of the fact that a multinational company has very much a lot of responsibility towards its clients, which are also located in different jurisdictions. And that point must further be appreciated by the information regulator. Hence, we are also having what we would call the GPAN, and we also have other bodies where we look at enforcement initiatives and enforcement cooperation between different jurisdictions. And as we speak, there is a common thread network which looks at Commonwealth countries and authorities that are placed in such a position to be able to assist when necessary and where possible, and actually then also make sure that they have a type of coordinated approach where possible. And what is also very important to appreciate is the Experian data breach that occurred in South Africa, and also because of the fact that Experian is a multinational company, what steps will different jurisdictions take. But it depends on the country, and it depends on the laws of that specific country. And one cannot provide a conclusive answer, but there are indications that if information of data subjects in a specific jurisdiction was compromised by a multinational company, that that authority will look at a way to engage that specific responsible party with regards to that specific data breach. Thank you. Maybe Mr. Nemasisi can add if you want, or Ms. Sulam. Thank you.
I think all I want to add is that if the processing activity had occurred in South Africa, then I think the regulator would have to look at how they would deal with it within the borders of this country. For me, that's just a view. Thanks.
Yeah, thanks. And Cambridge Analytica, I agree, is a great example of multi-jurisdictional investigations. And I must say, I was very surprised when the ICO came out saying that they really could find no wrongdoing after possibly the biggest investigation ever, which was very surprising to me, particularly after I'd watched all the documentaries and read everything and was convinced that there was lots of wrongdoing on the go. So that was interesting. But you're right, I think it does give us a lot of guidance. Maybe can we go back to Nathan Ross? Any other themes or questions from the attendees?
Yes, definitely. So some of our participants have mentioned that they are multinational companies, and they wanted to know essentially they have complied with, or they're working towards complying with the GDPR, and they have a data protection officer appointed in terms of the GDPR. And basically the question arises whether that same DPO can be appointed as the information officer as well. And so I'm guessing it would look at the roles and whether they're similar or not, or different at all. And then also whether the information officer needs to be domiciled and resident in South Africa for it to fulfill its duties.
Mr. Nemasisi, any response?
Thank you. Now, I think the first thing that we need to look at is that who's supposed to be the information officer. That's the starting point. Who can be the information officer of a body that's processing personal information? And you'll see in the guidance and guidance note that we have issued, that is issued for public comment, we have clarified that information to say, in terms of the public bodies, the CEOs of the public bodies, in terms of the departments, government departments, the HOD of those departments, and the DGs. For provincial department is the HOD, for them the government departments will be the DGs. Those are the supposed to be the registered with the regulator as information officers. With regard to the private companies, some companies will have a CEO, some will have an equivalent of a CEO as a managing director, and those are the people supposed to be registered as information officer. So depending on the, I haven't looked at the GDPR that they talk about as what is the requirement of a person to be an information officer. If that person that has been appointed in terms of that piece of legislation is actually equivalent to what our legislation prescribed, then that can be sufficient. But the Act does not indicate as to where the information officer is supposed to be. However, we need to look at the intention of having an information officer. Can they be able to render their duties wherever they are? But in any event, remember the information officer can also appoint a deputy information officers. And those are the people who assist them with regard to their duties, although the element of accountability remains with the information officer. So I hope that clarifies the issue as to who's supposed to be the information officer. So if in terms of any other legislation, I've in one of the same webinar that I attended, the question that was asked was, can we appoint our legal advisor as an information officer to be registered with them, or a compliance officer to be the information officer registered with the regulator? And the answer is no. There's an element of accountability with regard to the processing of personal information. And that's why that accountability can only be placed with the person who's actually controlling or managing the company. And that can only be those that I have identified. Thank you.
Okay, thanks very much. Anyone else want to add anything there?
John, if I could just ask Mr. Nemesis, I hear what you're saying, but are you saying that the CEO or the managing director, they have the right to delegate that? Yes, they remain the information officer, and that's always been my understanding, or they always have that responsibility. But they can delegate the role of information officer and the various things that the information officer has to do to another party. But that was not quite what I understood from your answer.
What I'm saying is that if you look at the Act, if you look at Section 55, the information officer, let's give an example, the CEO of an organization automatically is an information officer in terms of Pyre. Remember, if you look at Section 55, it actually cross-reference to Pyre. So the information officer, the CEO will automatically be the information officers, and that person is actually required to delegate or designate. Actually, they use the word designate any one or more person as deputy information officers. It then deals with those duties as to once you delegate, obviously you're not delegating the accountability, you're delegating the duties. So they will assist you. For example, if there's a request of access to information, so the CEO obviously is a very busy person. The deputy information officer will be the one who receives those requests for access to information and be able to facilitate. So if, for example, there's an investigation by the regulator with regard to the data breach, the deputy information officer will obviously be assisting the information officer with regard to any issue that the regulator might require in order to help the information officer. But the element of accountability remains with the information officer. So all they can do is to designate to any person who can assist them. What we encourage, because the legislation is not clear as to what kind of level of authority you can delegate to, what we encourage is that try to delegate to a person who have got some element of responsibility, because if those persons, that whatever they do, you account for what they're doing. So we need to ensure that the person that you delegate, you are sure that this person will actually execute their duties. And I'll give an example. Let's give an example with regard to the criminal conduct. Remember, there's the Act criminalizes certain offenses, and it talks about the fine or imprisonment. We know that the company will not be in prison. So it means someone will have to go to prison. The question is who will go to prison if there's that breach, and that will be determined by the court, obviously, as to who's supposed to go to prison, because the court, the company will not be in prison. But if the criminal, they said criminal conduct, and it says the imprisonment for 10 years, so you can't send a company to imprisonment. It means somebody else has to go to prison, and that will be the determining as to who take accountability for whatever that might have resulted in the criminal conduct. So it's very critical that even when you delegate or designate, you designate to a person who of much more responsibility, who will be able to account and assist you properly. And malicious compliance of just say will delegate to any person who's just a receptionist to be a deputy information officer, that might actually hamper the intention of the legislature, because that person is supposed to assist you, because as the managing director, you may not be able to be in the office on a daily basis. You need somebody who will be looking, assisting you in all those activities. Thanks.
Great. I think some of the key points I got out of what you've been mentioning is that the person can be outside of South Africa. The person should be relatively senior, and that the person who's going to go to jail would be the default information officer or the head of the body. That's some of the things I took from it. Thanks very much. We go back to you, Nathan.
I was saying, obviously, that will be the court will have to make a determination as to who's supposed, because it's not clear in the act as to when the issue of imprisonment comes in, who will be in prison. But we know for sure that the element of accountability remains with the information officer. So if the regulator were to report any conduct to the SAPS for investigation, obviously the person who will be the first accused will have to be the accounting officer, because that's the person who's registered with us. And that's the person who's responsible to do certain things, which if it's not done properly, those are the person that we can hold accountable. But the court will make the final determination on that regard. Thanks.
Yes, thanks. For me, the critical words there are when it talks about the offenses, it says any person who does A, B, and C. And so I agree, there are multiple people who could commit a criminal offense in terms of the act.
That's true.
Nathan Ross, should we go back to you? Any other themes or questions?
Yes, so moving along to something lighter, there was the question about why the POPI Act doesn't mention anything about cookies.
Masula, can you take that? Thank you.
I really can't. I think Mark is better placed to answer that question than I am. I'm going to throw it back to you, Mark.
Well, I think you must remember that the POPI Act was initially drafted. The drafting was complete in 2004. There were numerous delays before it got to Parliament. And even in its deliberation in Parliament, GDPR was then announced. And there was a question about whether we look at the GDPR and try and incorporate the principles. And the decision was made, well, the GDPR at that stage was still being discussed. It was essentially a document that was being looked at, and there was public comment and comment from the different member states of the EU. And Parliament determined, no, that we would not actually look at that. So, you know, the question relates, and possibly the analogy that I can give, yes, cookies are important, and cookies have been around for some time in websites, but they are recognized as one of those information security issues that one would need to look at. The other thing, though, is that you could then ask the question that why is social media not dealt with in the Act? Well, you know, if you'd asked this question about if we asked the question about social media in 2006, 2007, well, we wouldn't have had any answers, because Facebook only came about after that. And that is one of the important things about this law, and the fact that it is principle-based and not rules-based. If we try to create rules at the time, many of them would be outdated. It is also what it also indicates is the importance of the regulator and the regulator making rulings, because we are not looking at a static scenario. We are looking at something that is incredibly dynamic. And, you know, it's not just the technologies, but how they might be used in different circumstances that become important. And therefore, we are seeing things like what has happened in the European Union with the Schrems decision, etc., where there are business practices that are occurring using technology, and questions are being asked about whether that's legitimate or not. And that becomes so important that we recognize that the flexibility around POPIA is actually provided by the regulator being able to look at different aspects of it and determine in terms of the principle whether the processing is reasonable or not, and whether it is something for which the accountable party or the responsible party might be liable in terms of the administrative fines or other action that might be taken by the regulator. So I hope that that answers the question, but it does illustrate the very important thing, and that is that, that this is principle-based legislation. And what might be correct in some cases is not correct in others. I did see a question earlier on that might illustrate this as well, and that was the question around further guidance being given around what is reasonable information security. And that question is answered by the fact that there are volumes, literally volumes and volumes of information which relate to what information security measures are correct. And they differ in different circumstances. It will depend on the information that you're processing. It will depend on the purpose of the information. It will depend on the safety measures that you actually put in place, whether that processing is reasonable. And that type of flexibility comes about through principle-based legislation, but having a regulator, which we don't have to wait for 10, 15 years for the act to change, but that can interpret the act and actually provide rulings on what is reasonable in those circumstances. So I hope that answers the question, and Varsha, I hope that I've answered it to your satisfaction. Thank you.
I think you have, Mark. Thank you very much. And I think, you know what, people talk about technology neutral legislation, and I mean, if the advent of technologies, for instance, the Act doesn't cater for algorithmic biases or the Internet of Things. And I think the fact that it's a principle-based legislation is what will enable us to deal with any technology as they emerge. Thank you so much. Thank you.
I agree with those comments, and I think they're very good. Just quickly on cookies, I discovered something recently which really switched the lights on in my head. The definition of an electronic communication includes any text that is sent over an electronic communication network, which is stored in the network or in the recipient's terminal equipment until it is collected. So an electronic communication includes a cookie, which means it brings Section 69 into play. And in my view, cookies are dealt with in Pyre very similar to the European Union. In other words, for first-party cookies, you need to notify a data subject. So you should have a cookie pop-up or a cookie notice. And then if you're using cookies, and particularly third-party cookies in the context of direct marketing, because it's an electronic communication, falls into Section 69, then you need consent. So in other words, you need to notify data subjects of most cookies, and you need to get consent for marketing third-party cookies. And there's an article on our website that explains that in quite a lot of detail as to what our thoughts are around cookies in the context of Pyre. But I'm echoing what Varsha and Mark are saying, that Pyre is principle-based, and it might not specifically mention something, but often it actually does deal with the issue and is framed broadly enough to deal with it. Nathan, back to you. Any more questions? Well, I know there are lots, and so I'm also conscious of time. We only have 5 minutes going. I know Varsha's got a hard stop. So any other key questions? Maybe we got time for one more.
Yes, so I'll be quick with this one. It's basically about the information manual. So currently many companies have Pyre manuals, but now they're going to have manuals under Pyre. And the question relates to whether that needs to be a combined information manual now, or whether it should be two separate manuals. What would be the best practice when it comes to this?
Thank you so much. I think what is very important to appreciate is that we don't want to have separate manuals and a lot of other documentation and stuff. So what the information regulator has considered is the fact that it could be one manual that consists of Section A, which is the Pyre manual, and then Section B, which is the Pyre manual. So it's very important for us to understand that the manual will then be a combination of both the Pyre and the Pyre, but obviously with a Section A for Pyre and a Section B for Pyre. And that manual then becomes we refer to that as a single manual, but with two different sections. Mr. Nemasisi, would you like to add more?
No, nothing to add. You have covered it. Thank you.
Okay, great. I think I'm worried about time, and maybe then to start wrapping up, I think in terms of some next steps and where you can find more answers, I think one key thing would be to watch the Information Regulator's website. That's where various things are published, and the regulators mentioned a variety of guidelines and material that's going to be coming out over the next few months. So it's to watch that. We also, on the Michalsons website, we've got an FAQ section where we answer as many questions as we can there that are commonly asked questions. We'll also go through the questions that have been asked during the session and try and respond to as many as we can, either directly to you or through the website. And then maybe to launch this poll, I'd be interested to ask this question of whether you would like more sessions like this. And I really want to thank the Information Regulator for joining us today. Thank you very much for your contribution and being available. And overwhelmingly, the answers are yes, that people would like more. So I'll leave that there and just share the results quickly. So it's overwhelming that people would like more sessions like this. For those of you who said yes, but in a different format, we obviously always open to feedback. If you have any ideas of how you'd prefer to do it, would welcome those points. And then I think maybe the last point, just to mention from a Michalsons perspective, Michalsons, we essentially help organizations to comply with complex data protection laws. And we do have two options that we help organizations. The one is that you can join one of our data protection programs. And that's very much legal guidance. It's know-how. It's providing you with everything you need and empowering you to be able to take action so that you're ready for the deadline. And then the second way we help organizations is that you can consult with us as a specialist and we can do certain things for you. There's lots of information on our website that you can find out more about those two options and what's available. And we also offer a complimentary impact assessment that you're welcome to complete. And that's the purpose of that is to help you to understand the impact of POPIA and data protection on your specific organization, and also try and help you to decide what your next steps are, because it really is important, as we mentioned, that deadline is coming fast, it's not going to be extended, and it's really important that you start taking action now. So we're here to help, and hopefully we can help you as much as possible. Anything else from the panelists to add before we close?
Thank you so much. I think from our side, it's very important that we understand that during the grace period, it's not about an organization being free, from the compliance aspects. It is just that there's no enforcement as yet from the Information Regulator, but there is still a duty on responsible parties to exercise compliance with the provisions of POPIA, so that come the 1st of July next year, that they are in compliance, and the grace period is actually to prepare them for those compliance aspects. Thank you so much.
John, I would just like to reiterate your thanks to the regulator for making time to join us today, and for all of the participants. This is a very important thing, and one of the things that's very important to me is that the regulator becomes strong, that it is strengthened all the time, and that will need a collaborative effect, or a collaborative effort on the part of all of the parties that need to deal with the regulator. But I, again, just thank you very much, Colin, Marsha, and Nemasisi, for your time and for the candor in answering the questions that were posed. Thank you.
Thank you so much. It was an absolute pleasure. I think I just want to add one thing, is that the protection of personal information, it has to extend beyond a responsible party. And the fact that we live in a largely digitized economy and we're moving towards that, and there's going to be no retracing your steps from that point, that data subjects need to be prudent about protecting their personal information. And it has to be spread across the board, that responsibility. I don't believe if data subjects just rely completely on a responsible party, that information can be protected adequately. It's just a message that I believe in, that we should all take responsibility to protect our information. Thank you.
Yeah, I agree. And Mr. Nemasisi, any closing remarks from you?
Not much. I think Advocate Wiepond and Vasha actually covered everything. Just want to thank you for affording us an opportunity to come in and share our processes as to what our data subject and the public should expect when actually we become fully effective with regard to our enforcement power in July. Thank you so much.
Great. Nathan, anything from you before we close?
Perfect. Thanks very much, John, and thanks to all the panelists and participants. I just wanted to add that I think going forward, our relationship with the Information Regulator, it shouldn't be antagonistic. We should work together to create solutions, because at the end of the day, the priority is the privacy of all South Africans, and to ensure that a data protection, or at least we enter into a data protection culture within all organizations across South Africa. Thank you very much.
Yes, well said. I agree. Well, on that note, I think we should close the session there. So thank you very much for attending. I hope you found it useful. As always, we're very interested in feedback, and we're available to help. So thank you very much, and enjoy the rest of your day.